Hello and welcome again to Immigration News and Views. My name is David Nachman and with me today is Luke Zimochek. We're both managing attorneys at the NPZ Nachman Fulwani Zimochek Law Group. We have offices in New Jersey, New York. We also have an office in Indianapolis, Indiana, and we also have a presence in Boston and soon to be present in Chicago, Illinois. So today we want to cover something called unlawful presence. Many of you may be aware of how unlawful presence works. You know that probably after the 1996 Act, IRA was implemented, that there's a section of that law which says that if an individual overstays a date certain on their I-94 or enters the United States illegally or without inspection, that they accrue what's called unlawful presence. Unlawful presence means that they potentially start to accrue this number, and then after 180 days, if they leave, the departure being the trigger, they become subject to the 3-year bar. If the individual is here for 365 days and they depart from the United States, then they trigger the 10-year bar. So it's really a form of self-deportation. It was implemented under the law and it was designed as a way to hopefully stem the tide of illegal immigration to the United States. And slowly over time what's happened is that new provisions have been implemented which have allowed people to sort of circumvent these bars. And one of them was the traditional waiver, which we were doing back before the provisional waivers were allowed, where we would send individuals outside the United States and make a claim on an I-601 to say that they had extreme hardship to a qualifying relative, and that type of a claim would allow them to be able to re-enter the United States. And the thing was, though, that you would be outside the United States for quite a while.
Very long time.
Yeah.
And many families actually decided not to proceed because they were worried. We couldn't guarantee, none of the lawyers could guarantee the result, and sometimes they were stuck at the consulate for a year or two, and if the waiver was not successful, they would not be able to return, leaving families and wives and other relatives in the United States.
Striking at the very heart of the policy underlying U.S. immigration law, which is family unity. Exactly. Yeah. So then what happened was, in the law, there was this thing called the Provisional Waiver, which was implemented. And maybe, Luca, you can tell us a little bit about the Provisional Waiver and how it works?
Yeah. So Provisional Waiver was very helpful to many families. As I mentioned before, what it allows is to file a waiver in the United States. Instead of waiting for a waiver outside of the United States, the applicants can file the waiver within the United States, wait for approval, and once approved, then they would travel to their home country and process at the consulate. So it still could take 2, 3, sometimes 4 months to return, but at least those applicants were sure that the waiver was approved and they will be returning back to the United States.
Exactly. It's called, we refer to it as the know before you go provision.
Yes. Even though we've discovered
sometimes you don't know before
sometimes
you go.
You don't know because sometimes things appear for example,
not what they seem to be.
Yes, clients do not tell the truth.
For
example,
that they might have a criminal record, exactly.
Or fraud, specifically fraud.
Well, tell us why that's a problem. Why is a fraud a problem in the realm of the in the realm of a provisional waiver?
So let's say the waiver gets approved, the applicant goes to the consulate, and suddenly the consular officer finds out that 20 years ago, this particular applicant says he was single while he was married. And that would be a problem. The officer would find inadmissibility, fraud inadmissibility. However, the provisional waiver doesn't cover fraud inadmissibility. So that particular applicant would have to file a new waiver, a new 601 waiver based on the fraud, and would be stuck at the consulate for another year or more.
Exactly. And one additional item to point out, which is kind of interesting, and it kind of came into the law just about the same time as the substantive changes with the provisional waiver, and that is that we do stateside processing now of waivers, whereas in the past the waivers were processed at the U.S. consulates abroad.
That's correct.
So now what we have is a very level playing field where we have officers who are adjudicating cases from all over the world rather than them being keyed into the nuances of particular cultures. And that's a very important practical processing issue. Now, so one of the things that came down in November of 2014, and Luca and I were discussing it before we started the filming, is that there's this thing now called the proposed expansion of the of this law. There's going to be an expansion of the provisional waiver. So how does it change, Luca?
So right now, as it is now for provisional waiver, the qualifying relative is only U.S. citizen spouse or parent.
Okay.
With expansion, it will include also green card holder spouses and parents.
Exactly.
So it will be significant change. It will include a lot more people.
Exactly.
Which is great.
Exactly. So many more people will have an opportunity to be able to apply and know before you go. And this is, again, sort of goes to the family unity
Yes.
Provisions, or I guess the underlying policies that were inherent in that November of 2014 memorandum. So that's sort of a lay of the land on the history of the provisional waivers. If you or any member of your family, your friends, or any of your colleagues have any questions about the provisional waivers or doing waivers in general, please feel free to give us a call. Our telephone number and email address are on the screen. We'd be more than happy to assist you. Thanks so much for being with us today.
Thank you.
Bye for now.